Uh, Basically, I'm going to talk about how to understand our justice system a little bit so that we can protect ourselves. There seems to be a lot of injustices that are going on, and I think a lot of us are being blocked, and it's not really new news that the law has been basically instrumented in a way that attorneys are using it to oppress the people. And due to this injustice, I decided to go ahead and talk about my experience a little bit and to help others that may be in this situation, or give you a heads up of what your attorney should be doing and to ensure your rights. So basically, I'm just going to talk about personal injury. I'm not going to get into other issues, and but it'll be similar in a way. You only have 30 to 60 to 90 days on some statute of limitations, and those would be like your whistleblower. You have 180 days. So those of you that want to blow a whistle on your corporation, you have to write a letter to your CEOs and your management bosses certified. That means you go to the post office and send them a certified. Hopefully you type it up, and you make sure that you get the little green card back from the post office that you sent it certified. And then you get an attorney immediately, and you inform the attorney of the whistleblower laws. That means you Google it, look it up on the internet. And for pilots, it'd be Ford Aviation. Truck drivers, it's the Surface Transportation Act. And there's one for minors, and obviously for like Enron with the accounting firms, the Sarbanes-Oxley law. And on that particular one, with the accounting, cooking of the books, you would like to get a forensic auditor, and they only cost $5,000 to give you an indication if there is some type of monkeying with the books, cooking of the books, diverting of money. Then it could cost you up to $20,000 to get these forensic auditors involved. But anyways, in my case, I had a personal injury case, state of California, and the statute of limitations is different for every state. But bottom line is, it's 2 years now, and you want to make sure the first thing you do is that you inform your attorney and you sign a contract. And once you sign this contract with your attorney, you read this contract very well, and hopefully you get a contingency, meaning where the attorney doesn't charge you. But if he is charging you, that's a red flag. So you better be prepared in that contract and read it quite thoroughly, that you are, going to be able to pay. If they charge you, they'll charge you maybe $100. Some charge you $10,000. And after the $10,000's blown, which is usually within a week, 2 weeks, they'll charge you $30,000 for a case. So this should not happen. In Europe, they don't have a contingency. Lawyers only charge a fee. But here in the United States, the attorneys are supposed to be taking it on a contingency. Now, immediately, you make sure that when you talk to your attorney, that you want to know when the summons and complaint was actually given to the defense. And that's the key word. When did you submit the summons and complaint to the defense? And have you filed my claims, my case, in state or federal court? And there might be some concerns whether it should be filed in state court or federal court. If it's anything to deal with trade, it may be in federal court, or interstate commerce is usually federal. Airplanes and trucks usually may tend to be federal. However, personal injury, obviously, they can be filed in state court. Now, if the attorney delays, now this is a red flag, and you want to know what research he's done, because they'll sit there and sit on your case for almost 2 years, and then file it the day of almost the day up to the 2 year. Now this is ridiculous, and things should be done within 3 to 6 months, and you want to address this concern right off the bat. Otherwise, they're going to be working on other cases, and then what happens? The statute of limitation gets blown, and you're out. And then you got to go get a legal malpractice attorney, and they don't like suing other attorneys. I can tell you that right now. So, if you do end up having to sue an attorney, you basically get this, get a service, attorney service, and have them serve the summons and complaint. And that's usually meaning you had to jump in pro per and sue whoever it is you may be wanting to sue. And I highly recommend that you get a service individual, and they'll usually charge, $35 to $100. And you'll have to write up the complaint, and your complaint may look like this. And it's real basic. Your name would go here if you're in pro per. You're going to have the court, and then you're going to have here basically the case number, the name of the judge, and then you'll have here what it's dealing about. And this will always change, but they have forms as well down at the courthouse, and a computer that'll kick out these forms. Here you'll have the pleading paper. Usually this will be all blank, and then you'll have pleading paper with numbers, and you just stick it in backwards in your printer, and it'll print out, and then you'll have to draft up all this particular info. But it's easy. You have a date, a time, a department, and then whatever your certain situation will be. You'll put your name here, plaintiff versus the defendant. And then up here could go your own particular name. I just blocked this out because it's the defendant's. But anyways, then after you basically get an idea of these complaints, this is one for interrogatories. Now, interrogatories are basically about 200 questions, and these 200 questions, they could be between 50 and 200, depending. But they're all at the online, if you Google them, for interrogatories. So they're always going to pretty much stay the same. They may have special interrogatories, but I doubt it. And so you basically, you just answer your name, what happened during the accident, why you got injured, blah, blah, blah. And you just go and you have a case management. Now, hearing with the judge. This case management hearing, basically, you just talk to the judge, and the judge will monitor the case and make sure that the defendants have been served. Now, if the attorney doesn't show up to court, this is where the malpractice is starting to kick in. He's not showing up, he's not turning over your interrogatories, he's not giving your evidence that you gave your attorney, or whatnot. If you have to do it, go do it, because it's not that difficult, and the judges they're quite stern, but if you show some effort that you can do this and be your own lawyer, called pro per, litigation, pro se, doing it on your own, then they're going to go with you. They will try to knock you out on procedure problems, but it's not all that impossible to do. And if things are in a very detrimental situation and you have to do it, I highly recommend that you do it, because it's not all that difficult. Anyways, you'll go to court, and there'll be a calendar outside the court on the wall there outside the courtroom, and look at that, and it'll have your number on it, and may have a little piece of form there for you to put your name and what number you are, and you give that to the court reporter and bring your license, and then you go to court. You can sit in on other trials and gain information, and basically prepare yourself for a trial. And this is not all that difficult. You pick a jury, and it's actually not all that difficult. Your intuition needs to kick in, but usually the jurors are honest, and you will gain experience by listening to other trials that weren't dealing with your case. So I'm going to stop there and move to part 2.